I am the recently elected chair of BACL, and I have known Miriam for more than several years, so it is a particular pleasure to introduce this seminar about her book. Before I hand over to the chair, I would like to say a few words about BACL. The association was established in 1950, and just under 50 UK universities and other academic institutions are members of BACL, with the aim to promote the study and teaching of comparative law in the UK. So what do? We traditionally hold one annual seminar at the very start of the annual SLS conference, and we also hold every year a postgraduate research workshop where PhD students present their research and get some feedback from comparative lawyers in their field. For contemporary reasons, which I think do not require explanations, we are expanding into online activities, and today is very much part of that expansion. Our website now welcomes blog posts on comparative law project in whatever shape or form. And we are even preparing a YouTube channel, which it is hoped will launch shortly with the video of our 2020 annual seminar on climate change and the law in comparative perspectives. Turning to our seminar today, then, our chair is Dr. Uta Steger, co-founder and executive director of the UCL European Institute, and also Vice Provost for Europe at UCL. And Uta's main research interests are broadly in the relationship between culture and politics. So Uta, many thanks for chairing this seminar, and I'll hand over to you now.
Thank you very much, Sophie, and welcome to everyone to today's discussion. And I'm very grateful for the British Association for Comparative Law, BACL, that's new to me, but it's a wonderful acronym, for making this event possible. And also very specifically to Iseult Marik from the University of Essex for pulling all of this together and supporting us so expertly today. So as Sophie said, I'm from UCL, and Miriam has asked me to chair today's event, which really celebrates and discusses the publication of her most recent book. The title you can see on the screen, Why Religious Freedom Matters for Democracy, Comparative Reflections from Britain and France for a Democratic Vivre Ensemble. The book came out with Heart earlier this year, but given the circumstances, which must not be named, hasn't seen as much discussion as it really would have deserved. So we're very privileged to be able to properly launch discussion on the thesis of the book today. For very personal and professional reasons, really, I couldn't say no to this opportunity when Miriam asked. Miriam Hantanin is a reader in law and religion and comparative law at UCL, and she's been an absolutely inspiring colleague over the past decade. I think it's fair to say we have jointly plotted and successfully developed many projects together, while her work explored and critically assessed the principle of laïcité in light of French and European jurisprudence, and also with regard to differing conceptions of democracy. I've also really learned a huge amount from her on areas and controversies surrounding the role of religion in education, both conceptually and empirically. But today we're focusing above all on the workplace, in order to explore specifically how claims for religious freedom and competing rights often clash, how these controversies are embedded in and represented in two different national contexts, in England and in France, and also how important the pluralism of religious voices is to democracy as a whole. Now, to help us in this endeavour, we have three excellent discussants who are joining us today, and I shall briefly introduce them. Colm Ó Cinnéide is a professor of human rights law at UCL, albeit with a rather wide-ranging additional interests in equality and anti-discrimination law, as well as comparative constitutional law. He has also acted as a specialist legal advisor to UK parliamentary committees, as well as the UN, ILO, the European Commission, among others. And I suppose for any constitutional lawyer and anyone with interest in international law, today is a particularly interesting week to be discussing matters. Next up will be Philippe Marlière, also from UCL. He's a professor of European French and European politics. He shares interests with Miriam in terms of citizenship, religion and laïcité. He also works on French political parties, particularly those on the left, as well as on social movements and political ideologies. And last, but very certainly not least, Stéphanie Ened Baucher, who is Professor of Public Law at the Université Paris-Nanterre, as well as a senior member of the Institut Universitaire de France. She's also director of the Center for Research on Fundamental Freedoms. She has particular interest in, again, laïcité, religious freedom, bioethics, non-discrimination, and European human rights law. So a rather formidable lineup, I'm sure you'll agree. And before we go ahead, just to say a few words on the way we're hoping to make this work. In just a moment, I will give the floor to Miriam, who will set out the main arguments of her book in a very brisk 5 minutes too. Then I'll turn to our discussants, and they'll have each about 10 to 15 minutes to enter into conversation with Miriam, ask her particular questions, probe her, really conversational style. That's where we want to get to. And then after those 3 conversations, it is your turn. We invite questions from the floor. Please be so kind and use the chat function for this purpose. And we will then draw on your questions in the chat to put questions both to Miriam and to the discussants. I know this, this meeting's been set up for 2 hours, but I think we expect to be wrapping up at around 90 minutes, but having some leeway at the end. That's all from me. Thank you very much, and let me pass on to Miriam.
Thank you. I hope you can hear me. Yes. So thank you, Sophie, and thank you, Uta, for your kind introduction. And my thanks, of course, also to the British Association of Comparative Law, BACL, for organising the event, and again to Isolde Murig for all her hard work arranging it. I'm really grateful to the speakers as well, and to the attendees for finding the time to read the book in those difficult circumstances, and engaging with the ideas put forward in the book. So in 5 brisk minutes, no more, as Uta has pointed out, I will try just to give you an insight of the motivation behind the book, and an outline of the main argument I make. The motivation lies in the observation of growing clashes surrounding the right to and narratives of religious freedom. More and more intractable conflicts between religious freedom claims and competing rights reach the courts, and increasingly dichotomous narratives which oppose religious rights on the one hand and constitutional principles or national traditions on the other hit the headlines and feed into legal reasoning. In the book, I propose a less divisive approach. Why would we need a less divisive approach? Because I submit religious voices are important, not only for religious believers themselves, but also for democracy. The pluralism that religious freedom brings is, I argue, beneficial and enriching for democratic debate and democracy as a whole. My goal in the book is therefore to ensure that legal reasoning fosters these vital connections between pluralism, democracy, and religious freedom. To that end, my main argument is a democratic approach centered on 3 criteria of avoidance, inclusion, and revision, which I submit should guide legal reasoning. In a nutshell, what is the definition of each of these features? Well, under the method of avoidance, the state is to refrain from interfering with religious beliefs. Such non-interference, however, ceases to be justified if systemic disadvantage works against minority groups and vulnerable members of society. That is why the second feature kicks in. Under the principle of inclusion, the state must intervene to redress inequalities if need be. Finally, under the third feature, the principle of revision, the notion of reciprocity comes into play. Under the principle of revision, citizens would be expected to review their commitments in light of the overall political framework and vice versa. When citizens fail to do so, judges would legitimately set limits to their views and practices. This conceptual argument, very roughly explained, is developed in the book in light of a political philosophy debate. However, unlike most political philosophy work which stays at that abstract level, the democratic paradigm I defend is grounded in a sociological and historical analysis of two national stories of the relationships between law, religion, diversity, and the state in England and in France. Having proven that an inclusive approach to religious freedom was desirable in light of political philosophy, but also possible in each of the two selected jurisdictions, the second part of the book dives into legal analysis and explores the consequences of the democratic approach for legal controversies involving religious freedom in the employment sphere taken as an area of investigation. Whilst the principle of revision I advocate postulates that precise outcomes must depend on contextual evolving deliberations, guidelines nonetheless emerge for courts. For example, the method of avoidance and principle of inclusion combine to dictate that courts should not determine in advance which religious practices amount to acceptable manifestations, but take on board the claimant's interest in expressing her religious faith, however conspicuous or inconsistent the manifestation may appear at first sight. The democratic approach will also lead courts to scrutinizing the competing interests at play in the workplace without deferring blankly to the employers or to national courts' own assessment of the tensions. I will stop now, I think, to leave scope for questions. Thank you for your attention and in advance for all your comments and questions. Thank you.
Thank you very much, Miriam. That was very brisk and 5 minutes, and I'm very grateful for setting us off on such a good course. Let me ask Colin straight away to comment and provide questions to you.
Okay, thank you very much, Uta. And Uta had asked me earlier how to pronounce my name, which is always a source of considerable terror to everyone, Irish people included. And I'd like to congratulate her on one of the best versions of it I've ever heard, better than most Irish people. I'd like to begin by saying how enjoyable I found reading Miriam's book. It has something that's rare and increasingly original in academic terms, which is that it's incredibly clear and well written, which is a wonderful thing to see. It also, of course, has the benefit of immense contemporary relevance. Even this morning, and I'm not going to ask Miriam about this because she might even have seen it yet, let alone formed an opinion. There is an Advocate General's opinion, Advocate General Hogan, the Irish Advocate General, in the Court of Justice, has just issued an opinion on a legal challenge against the Flemish ban on slaughter of slaughter of animals without them being stunned beforehand. In other words, the ban that prevents the killing of animals that would satisfy the requirements of kosher and halal. Advocate General Hogan suggests that that is actually contrary to EU law, the relevant regulations governing animal killing, interpreted in light of freedom of religion in the EU Charter. That's just 10 o'clock this morning. So that just, I think, very nicely illustrates how contemporary and up-to-date Miriam's book is. So it has the virtue of clarity, it has the virtue of contemporaneousness, and it has the virtue of being, I would say, largely convincing. Her argument, I think, is exceptionally well developed. It very much, I think, captures the need for a middle way between what she describes as the disaggregationist, the sort of disaggregationist secularist approach on the one hand, and on the other hand, the accommodationist approach. A middle way between an approach which would very much treat religion as just another form of philosophical social conviction, which would very much relegate consideration of religion to the margins of legal analysis, versus, on the other hand, an accommodationist approach that very much carves substantial exceptions out from laws of general application. Miriam's approach, I think, rightly tries to steer a middle course between what she sees as those two extremes in a way. And I think very convincingly argues that such a middle course is desirable, that it is possible, and she outlines how such a middle course could be developed. And I think the argument, the book is fascinating for how well she develops that, and the depth of her argumentation, drawing on both philosophical and legal sources, while also simultaneously, and another feature of the book I particularly commend her for, rooting it in a sociological analysis of current conditions. This, I must say, is something that's often lacking in consideration of debates about religious equality, religious accommodation, and so on. I think that there's an acontextualism, a failure to take into account the current contemporary context in which we find ourselves, and also a failure to take into account the extent to which existing law and constitutional traditions in states have been shaped by previous historical contexts and by assumptions about the nature of religion, which are no longer perhaps sustainable in contemporary circumstances. That's all the nice things I have to say. Very much my overall view is enormously positive. I enjoyed reading it very much. I did have 2 points I thought I would ask Miriam about, two elements of her argumentation I thought I'd zero in on a little bit. The first element of her argumentation relates back to the distinction she draws between her middle way approach and what she describes as the analogous to secularism approach, or the disaggregation approach, which she argues that philosophers like Cécile Laborde and others have put forward and developed, and which is perhaps finds some reflection in the French secular tradition and other secular traditions across Europe. Miriam argues that this approach, as I've already mentioned, suffers from not giving enough account to the salience of religious belief and formation of freedom of thought, that it gives insufficient weight to the importance of religious belief in personal makeup and in the formation of beliefs, and that in particular in contemporary Europe it fails to take into account the way in which traditional European concepts of sort of private belief versus public participation and citizen isn't a line that's particularly sustainable when it comes to the current growing diversity of European societies. I did wonder whether Miriam's very powerful critique of that tradition was based to some extent on a variant of that tradition, was based upon elements of that tradition that tended to rigorously downplay the specific nature of religious belief. And I did wonder whether her third way analysis, with its interest in equality and non-discrimination, mightn't be so different from that approach if that approach were to be, in a way, reinterpreted The secularist approach has historically said, we're not going to take into account private convictions. We're going to, laws, for example, should be addressed to all citizens equally, irrespective of religion. And then, so the question I want to ask, Lucius says I should ask it one at a time, is when Miriam says we need to vary from this, we need to take a more contextualist approach. Is this a departure from that approach, or is a radical break with this approach, or is this actually a modification of the secularist approach, perhaps an adjustment to recognize the fact that religion is conceptualized and understood in different ways? That would be my first question. I have a second follow-up question, but over to you, Miriam, for your initial response.
Thank you, Colin, for the update first from the Court of Justice, and also for your very profound and insightful question, which boils down to whether my objections to the analogous to secular approach really are fundamental. I do share the objectives of the analogous to secular approach, and I want to make clear that I wouldn't have any qualms about protecting secular philosophical beliefs. But what I take objection with is the stronger claim made by analogous to secular authors, according to which the category of religious freedom only exists to ensure equivalence between religious and secular commitments. So I have no problem about extending the category of religious freedom to secular commitments. But I do have issue about the idea that religious requests are only protected or should only be protected to the extent that they are secular equivalents or underlying secular interests. In practice, what does it change? I think that the democratic approach insists on the value of pluralism in itself. So under the democratic approach, religious diversity is not protected only because of liberty or equality concern, but because pluralism has value in itself. And this also emphasizes, you said, the roots of religious freedom protection, the historical genesis of religious protection in law. I think that there is a risk in the analogous to secular approach to obscure this broader picture, to lose sight of the cultural, historical, sociological roots. And this would affect our understanding of legal solutions. It would affect how we conceive law and hide the fact that law and the political have constructed themselves within and against a certain relationship with religion. In current populist times, when religion fuels dichotomous narratives of us against them, I think it is, on the contrary, helpful to be reminded of the full complexity of law, including its connections, particularly with religion.
I happen to actually agree with you on that. But there may be, so I will leave it to others to take up that that particular narrative. But I certainly, yeah, I mean, that makes sense to me. Though others may very well have quite radically different views on this. My other question, my second question I was going to ask you, again, taking up this, your concluding point about the flexibility of law, the revisability of law. You describe your approach as a democratic approach, you know, that it's going to be open to contestation, open to revisability. But then the deeper you go into your book, the more a strong role for judges applying proportionality review emerges. So you see this in your analysis of the Ladele case, where you call into question the failure of Islington Local Borough Council in North London to accommodate the views of the registrar who did not want to register same-sex couples. And you suggest, without saying they were necessarily wrong, but you suggest that the rationale for their approach and the failure to accommodate her belief should be subject to fairly exacting proportionality analysis. Now, that is a democratically elected local authority in a sort of very left liberal, a famously left liberal part of North London, taking a decision in the interests as though they saw it of maximizing same-sex equality. And you are suggesting that their decision should be subject to fairly exacting proportionality review by a court. Now, some might suggest that that's not really a democratic approach, that it could be very much a sort of a rights-friendly approach, an interpretivist Dworkinian approach, or something similar. But what it's not is that it's not a democratic approach as such. So I wondered what you thought about that.
Yes, thank you. It's a very astute point. I think there are two elements in your question. What do we mean? What do I mean by democratic approach, democracy? And isn't there a risk that I sort of undo contextual decisions and replace them by judge-made decisions? On the first question on democracy, I do not mean democracy as a majoritarian parliamentary process of decision-making. I use the word democracy as a process, inclusive process of deliberation, hence the role of the courts. Because as I argue, courts can have a valuable role in order to foster these qualities of diversity, inclusiveness and revision. And so when this process of deliberation in an inclusive, egalitarian way has not taken place locally, contextually, courts can intervene. So it's not a rights-based approach in the Dworkinian sense, because courts, although they have more legitimacy in intervene in order to foster deliberativeness and not in order just to impose rights. Undoubtedly, their intervention, judicial intervention, will not be merely procedural. It is fostering, it's not neutral, it's about fostering ideals of neutrality, not of neutrality, but of inclusion. But nonetheless, it's about fostering deliberativeness rather than just imposing rights in the Dworkinian sense. So in the case of Liddell, for example, I don't believe there was an obvious wrong or right answer. And certainly from a legal point of view, Islington Borough Council was absolutely entitled to refuse to grant any exemptions to Ms. Liddell. Under the Civil Partnership Act, local borough councils had been granted the discretion to decide whether to grant exemptions to their registrars on religious grounds. Islington Borough Council, for obvious political reasons, had decided to commit to the equality policy between same-sex and opposite-sex couples fully, and had denied all exemptions. I know that some authors have argued that Ms. Liddell had no case at all for that reason, and because her request went against the principle of equality. On the other hand, authors argued that same-sex couples had no interest, no case at all, because even if Ms. Liddell's request had been granted, they could still have found another registrar and got their ceremony celebrated. I personally believe that actually there was a genuine conflict in the case, genuine competing interests were at play. And what I criticize under the democratic approach and what could trigger intervention of the courts on the democratic approach is not therefore that the Islington Borough Council took the wrong decision, but that it took the decision in a very disparaging climate against Ms. Liddell's view. So that would be, for example, a reason for the courts to step in, because the disparaging climate precluded from the start the conditions required for an inclusive deliberative process to occur locally.
Okay. You and I, of course, can take this up further in Bentham House in UCL. I will put
when
my
we come
little
back,
asterisk. I will put a little asterisk there, and perhaps hand over to Philippe. But congratulations again on an absolutely wonderful book, which raises all these absolutely fascinating and key questions.
Thank you again.
Thank you, Colin. Thank you, Miriam. And I like the asterisks. You may try and insert the asterisks later in the free Q&A that we're putting forward as well. So happy to come back to that. But yes, let's turn to Philippe. I mean, it's part of the joys of this panel is that we have lawyers and political scientists joining. So very much looking forward to your views, Philippe.
Thank you, Uta. Hello, everyone, and thank you very much for inviting me. It's a pleasure to be here. Like you, Uta, I couldn't decline this invitation because I've known Miriam for a while, have had a chance to discuss a book while in progress, and I think it's remarkable how fast, I'm not saying you rushed it, but how fast you completed it, considering the depth of the argument and the difficulty also of the topic. You know, it's very brave to dare a comparison between France and the UK on such a topic, because for teaching a course along those lines, you know, models of citizenship integration in France and the UK to second-year students at UCL as a political scientist, and I will step in the conversation as such, I realized that on the British side, no one or very few people understand the French model, and vice versa. On the French side, no one understands or very little of the British model. So you did that. Of course, it takes a Franco-British author to do that. I also know it's quite inspiring to read your book because, and also I think here of Cécile Laborde already quoted, mentioned that it probably takes a French author to reflect upon, you know, the situation in France when it comes to religious freedom, and write things which I believe, and no offense to the French colleague who's there, but I think it probably takes that to be sort of looking at one's own country from a certain distance to probably come up with very new and stimulating approach and insight into the issue. And that's really what I liked about the book, which is really a tour de force, because you combine legal, of course, but also philosophical, historical, sociological elements in your book, and you do it so well, and there's a wealth of references. And I think you did all that in 2 to 3 years. That's quite amazing. You worked very hard, so well done, congratulations. I think the whole thing about the vivre ensemble, literally living together, is also a good starting point, because particularly from the French perspective, and I will, as a French expert, I will concentrate on the French case study here. The sort of, it remains to be seen whether religions are seen as something which can sort of gel nicely and fruitfully with society and with civic liberties in general. And of course, there's a next issue is, what religions are we talking about? And I think when you talk about the broken vivre ensemble, the living together, which is broken in your first part, I think, of course, you point out, you identify the very uneasy relationship of French society as a whole to Islam in general. So it's not all religions which are put on the same footing here. There are religions which are allegedly more compatible with the living together, and others which are seen as less compatible. And I'm thinking here of the ongoing debate which has been unfolding as we speak in France the past few days, you know, starting with, you know, within the government of France about separatism, that's the new expression coined, literally meaning without never outlining or defining very clearly what kind of groups of people they're talking about. But everyone understands it's about essentially Muslims not fitting well in the sort of vivre ensemble. And I think that's really, of course, it raises issue about freedom, about civic liberties in general. And I think I will ask you a question about that in the end. I find your typology, in fact, I think you inspired by Grimm, but essentially you use it very well between the three types: militant, separatist, and the positive constitutionalism, which is the sort of paradigm, liberal paradigm, which you bravely attempts to outline and defend. It's becoming very fast unfashionable to be defending in our populist times a liberal paradigm of right. And I support you on that. Well done. Well, the militant type is interesting because really it's the one which clearly seems the most unsuitable with our societies today, multicultural societies that is. And I think the UK and France are par excellence multicultural societies. The difference between the two countries, it seems to me, is that although the UK, probably more reluctantly now than 20, 30 years ago, accepts to be being a multicultural society, in France, France is in denial about that, at least from a legal, constitutional point of view. Separatist, which seems to be historically the French paradigm, which is with the separation of the church and the state. This is what we've got in France since at least the law of 1905, which in theory separates the realm of the church and the realm, i.e. all religions and of the state. And the third one, positive constitutionalism, is the one where probably the British model could fit in, although there's been sort of a few changes. And in fact, the French and British models, I don't like using the word models because it's very stereotypical, of course, but in fact, there's a more convergence and sometimes overlaps than one might think between the two models. So you do that, you use that very well, in fact, to sort of highlight and also shed lights on the differences. I don't want to talk for too long, Uta. It's probably already at least 3 minutes. The point I wanted to make before asking my first question to Miriam is about how the French models seems to oscillate, seems to be very uncertain between the two types, the militant and the separatist. I said, in theory, it should be separatist. At least that's the way the French model conceives itself, as a separatist model. But there are always forces, or I should say temptation, to get back to the sort of revolutionary model, the post-1789 model of militant, whereby clearly there are forces, people, groups in French society which would like to confine or religion, and not simply in terms of worshipping, but religious signs like the ongoing saga on the hijab in France, to the so-called private sphere, which from a legal point of view is always something which needs to be strictly defined, and the media or in politics, when people use that notion, it's never clearly defined what is the private or public sphere. So I think there's an oscillation between the two, which in my view is the big problem, which seems to, and I'm sort of getting to the point of, let me ask you the question now. I said very bravely, and I support that sort of approach, defend a liberal paradigm, and I wonder how confident are you that such paradigm will one day become dominant in French society? How far is French society from that? Because you set out in your introduction, the three elements: avoidance, inclusion, revision. it seems that you're more optimistic than I am on that. And I'd like you, as my first question, to elaborate on how confident are you too that France could fit your model in the end?
Thank you, Philippe, for your compliments, and thank you for the very difficult and exciting question. I wouldn't want to make predictions, and I'm not saying that I am very confident at all, but I still think that it's all the more important to counter the dominant discourse, because I agree entirely with you. I agree with you that French laïcité as a concept is probably closer to a separatist type, but that as a narrative now and in people's imagination, it belongs more and more to a militant, anti-pluralistic and anti-religious type. So I'm not very optimistic. However, I think it is important to counter the narrative, to at least dispel the myth that the militant type would be inherent in the French concept of laïcité. I think that certainly, as you say, there have been periods in French history, and we think of the French Revolution straight away, but probably also a few years in the Third Republic, where the Catholic Church's influence was forced most aggressively, and the model was clearly anti-pluralistic. And this history has left its marks on how the French view law and laïcité. But I think it would be reductive to see laïcité exclusively through this militant prism, and that's the dominant political discourse tends to see laïcité exclusively on those terms. So I think as academics, it's still important for us to try and dispel the myth. I'm not naive to the point of thinking that a history lesson will suffice. And I realize that it's not only a misreading of the past, but fears about the future, really, and fears about a more visible Islam that drive the militant streaks. Here, to fight those fears, I think that comparative law can be useful. Again, it shows that those fears are shared elsewhere. And again, this helps undermining the idea that a militant style, anti-pluralist style would be typically French. And also law can help. I think legal reasoning has a vital role to play. If courts and legislatures engage with religious freedom issues more contextually and refuse to make sweeping statements about Islam, integration, etc., I think that would be encouraging, and maybe the fears that support the militant streaks would lose some of their grip, hopefully.
Thank you very much for your answer, and apologies for putting a difficult question to you, because whenever you ask something to predict the future, you know, it's not a fair question in academic terms, and I take it. But I think it was very interesting. I wanted to sort of know how you felt about the whole issue of you know, you are as an academic sort of thinking about a paradigm, something which could really help go forward in this debate on religious freedom, and then you know the state of the debate on the ground in France and also in the UK, and you know that there's a big gap between the two. So that's really the sort of how useful, how convincing our arguments as we make them as academics can be. And I agree with you. It's not because the task is difficult that we should give up on it. My second question is, it's a bit again of not coming at all from a legal perspective, but as I said, I'm a political scientist, and I'll sort of and I finally wonder, when we talk about religious freedom, whether we are actually talking about religion. Aren't we? Isn't it in the end a kind of pretext? And again, probably that is more the case in France than in the UK, that what we're talking about something a bit different, wider, deeper, probably more bigger. I don't know what the Americans, for instance, call culture wars, you know, because this seems to me, you know, when you follow those endless ongoing debates on laïcité in France, you know, there isn't one day in France where you have a new controversy about that, and I'm not exaggerating here, and see how people approach the whole notion historically, politically, sociologically. It's really anything goes, and really, particularly in the media. Isn't it, you know, about something wider, for instance, about how, you know, about national identity, how the place and role of France in the world, France and its relation to the EU, whatever, you know. But it seems to me that it seems to be handy to hide behind this notion of, you know, it is difficult to integrate religions, notably Islam, as I said at the beginning. Whereas in fact, it's the sign, this ongoing debate on religious freedom is the sign, and it's the difficulty of integrating religions, a sign of a wider malaise. So again, how do you feel about that? And I hope my question makes sense.
It does make sense, and again, it really hits the nail on the head, I think. But it's not any less difficult, Philippe, to answer.
Sorry.
That tells me I have to answer very quickly. So I will just say that, yes, I agree. I agree with you. And the comparative perspective revealed that, confirmed that religious freedom controversies were a way of revealing a deeper malaise and a general debate about national identity. But I'll stop there for now, because
Thank you.
I'm going too far. Thank you.
Thank you very much, both. I didn't mean to be quite so radical in saying one might consider slightly concise answers. I didn't mean to cut you off, so please, you know, I don't want to cut off argument. What I'd like to do is obviously have time for all of us to extend the argument, and it's in that spirit that I'll pass on to Stephanie to be our continental invitee today. For all our various identities. I think Stephanie is the only one who's based in France at the discussion today, and hear her thoughts, and allow then later enough discussion, Miriam, to go back to any points you feel you may have not been able to comment enough on. Thank you. Stephanie.
Okay, thank you very much. Is the sound good and everything? Yeah.
Yes, thank you.
Okay. Well, first of all, thank you very much for the invitation. Thank you, Miriam, and thank you to BACL. I'm very happy to be part of the book discussion and get to meet or see again colleagues that I always read with a great interest. So it's really a treat for me to be part of this conversation. And of course, the invitation also provided me with the opportunity of reading Miriam's book. I'm familiar with some of Miriam's previous work, and I'm happily familiar with it. It's always a pleasure to read her work. But like Colm and Philippe, I have found reading the book very interesting. I think it's a very ambitious, both comparative and theoretical contribution to these very difficult debates on pluralism, democracy, religious freedom. So I'm very impressed with the outcome, and I guess I just want to maybe organize my remarks and comments around along two main directions. First, I'd like to make a number of comments and get to a question on the comparative dimension of the book. I have, as others, highly appreciated the choice of comparing French laïcité and what I think at times in the book you call British establishment. And the overall conclusion that you reach, which is that for all their historical and technical differences, both the British and the French models are simultaneously amenable to inclusive policies, or at least they have been at moments in time. And they're both also nonetheless being pulled in exclusionary directions in more contemporary times. And I really fully share that reading that is, you know, I'm making this very short, but in the book it's very rich, and it, you know, it goes back in history and in doctrines or philosophies of laïcité or establishment. So it's a very savvy comparison. But as I was reading, I got really curious, and I would maybe like to ask you a question about your understanding of the driving forces that are pulling both models in these more contemporary exclusionary dimensions. In France, for instance, which is of course the model that I know best, there is a quite specific political and intellectual history of disrupting the dominant throughout the 20th century liberal understanding that was entrenched in both law and political debates for the most part of the 20th century. I mean, really, things started getting illiberal or exclusionary or whatever at very particular moments in time, and especially for this contemporary moment by the end of the 1980s, and even more so at the beginning of the 21st century. So there are very specific groups of intellectual and institutional actors that have played a very important role in France in redefining laïcité over the past 15, 20, 25 years in this more exclusionary dimension. And as I was reading your book, my curiosity was really piqued as to the history behind the British overturning of this liberal, inclusive reading of religious freedom. So you certainly give some elements of contextualization, and you refer to increasing anxiety towards radicalization, some forms of, or some religions in particular. But I would be really interested to know more about the actors, the turning points, and I don't know, I think that the history also needs the sort of, I don't know how to call it, maybe sociological or sociopolitical part in order to identify the actors and the slogans and the core issues. And just to get to my, or to wrap up that question on the comparative perspective, I guess I also have a question about, I was really struck in the book by the moments where you explain, for example, that schools in Britain now have a duty to promote fundamental British values. And of course, there is an equivalent political and now legal standard that has been gaining traction over the past 15 years in France, which is the Les Valeurs Essentielles de la République Française, that come up in litigation and in political debates in a variety of domains, not only religious freedom or laïcité, strictly speaking, but also nationality law, immigration law, and everything. And what I find really striking is that the way the Department of Education, as you quote it, defines fundamental British values, they still include tolerance, pluralism as fundamental British values. Now, I thought, you know, it might be interesting to notice that whatever definitions that we get of the standard of Valeurs Essentielles de la République Française, they never include tolerance or pluralism. And what they do include instead is laïcité, of course, in this sort of new redefined way, gender equality, which is of course something that is then pitted against a number of religious practices or beliefs, etc. So maybe, I guess I'll just follow up on something that Philippe was saying to end this question. The comparative perspective is really rich, but I really value the ways in which you try to show that there are some comparable or similar dynamics in both the models, but isn't really the French model more doomed than you say in comparison to the British one?
Thank you, and it really follows up nicely onto Philippe's question as well. So it's perfect, and it will perhaps allow me to come back to your last question, Philippe, as well, which have really rushed. So first of all, thank you for your excellent questions and your thorough reading of the book, Stephanie. It's true that through the interdisciplinary comparative investigations I did, I came to the conclusion that the French and the English stories were following converging trends, and in contemporary times had the same tendency to call upon national values to solve religious freedom controversies. There are nonetheless differences, of course, and I maybe insisted on analogies. There are very similar driving forces, though, behind the exclusionary trends in the UK and in France. For example, a fear of extremism. The duty to promote fundamental British values, which is probably a good emblematic illustration of the exclusionary trend in Britain. This duty came up and was introduced in 2014 in the curriculum guidance for English schools as a direct consequence of a scandal, the Trojan plot scandal. Yeah. After a number of English schools in the Birmingham area were reported allegedly to have been taken over by Islamist groups. So there was a fear of religious extremism, which is shared in France. Also a fear of terrorism, and the two, extremism and terrorism, being conflated often. The duty to promote FBV, so fundamental British values, we'll say FBV for short. This duty took more vigor in reaction to terrorist attacks, and it would be complex to explain, but has evolved in the shadows of a prevent duty, which imposes on public authorities the duty to report on anyone at risk of falling prey to terrorism. There are also political forces at play, and so we may not have laïcité here and political forces using the concept of laïcité in exclusionary way, but we certainly have a populist shift in British politics, unfortunately. And this shift tends to portray minority ways, whatever they are, including religious ways, as suspicious, as a threat. And this has fed into the duty to promote FBV. Also more contextual, I guess, but education has changed. So there's increasingly a more top-down approach to education in the UK. So that's probably always been the case in France, but that's new in England. In that state intervention is now more common through Ofsted, the body of inspectors, in areas where in the past the state would not have interfered. There's also a growing hostility in Britain, which might be more acute than in France, towards external sources, European Convention of Human Rights and EU law. And as a result, there's a growing inclination to rediscover Britishness from within. So it is interesting that tolerance and diversity are quoted within FBV, but Britishness is quoted as well. And there's an idea that somehow there is a British way of doing things that excludes those who are not British or not British enough. And the Muslim other seemed not to be British enough in certain instances. So that's what I would say as a very general answer.
Yeah, great, thanks. No, I I think you're absolutely right, and I mean, it was really striking to me to read about this the standard of British fundamental values, and I really think that, you know, this would be a great further project to do more comparative work on the genealogy and the uses of both these standards in both countries. But maybe I'll move on to a second sort of set of remarks and questions that is less on the comparative dimension, but more on the theoretical aspect of the book. And again, I will join Colm and Philip in insisting on the many qualities of the book in terms of clarity and richness of the normative points that are made, and all the normative conditions that you mentioned earlier: avoidance, inclusion in revision, as conditions for fruitful, inclusive, and deliberative articulation of religious freedom and democracy. You do that in a very sophisticated and convincing manner, and I think it's I mean, I really hope that all the people who listen get to read the book soon. I guess my second, the question I want to ask now is, will very strongly express my own academic identity and reveal that I am a human rights lawyer much more than I am a political theorist. And I say this because I think there are important consequences in terms of, in epistemological terms, so as to the very identification of the reasons for which we might find it useful or important to reflect on the relationships between law and religion. So when we do that, do we seek to refine a theory of democracy, or do we seek to find the most desirable articulation of law and religion as normative orders? Do we ask purely theoretical questions? Or do we seek to ensure that the rights to religious freedom or the rights to non-discrimination on the basis of religion are indeed guaranteed? And I guess this is just a very complex and maybe not very clear way of asking, again, I think, almost the same question that Philippe was asking before. I think he asked you if you really thought that, you know, there was a slight chance that thing would evolve in the direction that you prescribe. I wouldn't ask the question exactly that way, but I must confess that for all the admiration that I have for the architecture that you designed, I struggled at times when I was reading the book to see or believe that purely normative models, refined as they may be, stand a chance against the powerful intellectual, institutional, and political forces that we see so powerfully engaged in stunting religious freedom, or at least the religious claims of some minorities. So this is a point, I guess, that goes to the more political theory, normative aspect of your project, but it also goes into your reading of some of the legal cases that you take your readers through. And I was really struck by the fact that, of course, I mean, you know, all the legal discussion that you do of the cases that you present is very convincing. But I was wondering exactly how you managed to have purely legal discussions about some of these cases, as if it was not necessary to bring in to the discussion of the cases much of the dirty politics that they're also made of. And, you know, I won't go into some of the cases that you mentioned, but just for example, the BACL case, where you, of course, you very rightfully say that the Cour de Cassation says that private employment is not a matter to be regulated by the constitutional principle of laïcité. And I mean, you describe that and it's written in the decision, but it's really strange because the true legacy and the true takeaway from the whole BACL case was not one of containment of laïcité, but was one of expansion of laïcité and in fact redefinition of laïcité, very contrarily to what the Cour de Cassation eventually said, in the sense that laïcité is now understood in the public debate as synonymous for religion should be in the private sphere. Laïcité as a requirement applies to private individual, which we as lawyers can say and shout that it is not correct. But there is this, the narrative, the political narrative that surrounds these legal decisions is so powerful that I sort of found at times that this was a bit lacking because, I don't know, it's my pessimistic view. And, as a human rights, religious freedom lawyers working on laïcité for 15 years, you have to, feel for me. So at times I was just a little dubious as to the ability of these normative models to actually help us do the counteracting that you were referring to before.
Thank you, Stephanie. And it does go back to Philippe's point about how persuasive my ideal of inclusiveness can be in current tense context. But so I will just limit my answer to the more legal aspects and maybe to the BACL case. So maybe to remind everyone, in that case, the Cour de Cassation in its final decision ruled that a private nursery known as BACL could lawfully require one of its employees to remove her non-face covering Islamic jilbab in line of the nursery's neutrality policy. So I am very critical about the decision, and we both wrote critically about the decision before. I am, however, I say I approve the decision in avoiding laïcité as a legal basis. And I say that in comparison to the Eshbita ruling, this is better because in Eshbita, the Court of Justice of the European Union does suggest a bit more strongly that laïcité could be applicable, even though it's a private law context. I am aware that even if laïcité was not used as a legal basis, it nonetheless applied in spirit and certainly in its consequences, and in a way therefore reinforced the narratives. So does it make any difference really whether the Cour de Cassation uses laïcité or not as a legal basis, if in the end the restriction to the employee's religious freedom are still upheld? I think it does, though. I think it does make a difference. Maybe not right now, but for the future. And I think that ruling out laïcité as a legal basis at least allows more scope for further contestation of the decision in the future. In future similar cases, and indeed it happened, subsequent courts, especially supranational courts, will feel more empowered, I think, to refine or even contradict findings on proportionality than go back on the scope of laïcité. So it matters not only for my personal taste for coherence and accuracy as a lawyer, but I think it does matter for the discourse as well, actually.
Okay, well, thanks.
Thank you. Thank you so much to all of the discussants and Miriam for so bravely standing in your post there, defending and arguing and explaining your approach. As usual with these things, we've gone slightly beyond what we said we would, but it doesn't matter. It's been a really interesting and lively conversation. And let me proceed now to the more sort of open discussion, because we've had one question which, in fact, I think segues quite nicely from the last points that we've been touching on. It comes from Sophie Turenne, and she effectively asks, as you can see, about the role of courts and your suggestion to provide guidance, and whether there is any evidence, no matter how desirable, but is there any evidence that courts would be willing to endorse your approach, or what the obstacles might be, both in the English and the French case, to the actual courts acting differently?
Yes, it's a very good question, Sophie. I think the obstacles are quite apparent from the discussion we've had, but there are a few good students, really good cases. There are few, but I think the Eggenberger case that comes from not from an English or a French court, so I'm not taking side. It's from a ruling by the Court of Justice of the European Union. Would probably be compatible with my democratic approach, in that the courts stepped in order to ensure that there was deliberation. It refused to adopt a reasoning in terms of spheres which would give the upper hand to the employer. It sort of insisted on having a proportionality test which allowed a true balancing of competing interests, and insisted that the goal of inclusiveness as set out in the directive, which was applicable, was respected. So I think, without going into too much detail, I think Eggenberger, for example, would be one illustration of a good practice.
Thank you very much, Sophie. Would you like to respond to that, or shall I move on? I'd be very glad to. Do let me know.
I think that was the answer I was hoping for. Thanks.
Fantastic, thank you. Because we have a very good follow-up question now from Oliver, who takes the discussion on to the European dimension and therefore to the CJEU. Now, your book's on the national courts, of course, not on the CJEU. But the question is that the sort of inclusive model, this positive constitutionalist model that you propose, is that something the CJEU should also adopt, if you like? Should it either stand aside, avoiding a kind of centralization of fundamental rights and just leave it to the member states, or should the CJEU prescriptively intervene, you think, in debates? And if so, why?
Well, I think Oliver is the expert on constitutionalism beyond the states, but I agree entirely with his argument in his book, actually. And my democratic approach, would not be limited to the national sphere, with European courts just stepping back. I would urge the supranational courts to adopt a democratic approach as well, so that deliberation can occur at that judicial level as well. So I would draw a distinction between deference and delegation. In some instances, deference to national context on the part of supranational courts could actually be a good thing and be compatible with the democratic approach when needed to make sure that the debate nationally is not hindered. But sure, it mustn't veer towards delegation, because otherwise then there wouldn't be any more dialogue and interaction between supranational courts and national courts. And also it would mean that the guarantees of equality and inclusiveness might, as entrenched in European law and the Charter and the directives and the European Convention on Human Rights, would be undermined. So I'm not sure. I hope it answers Oliver's question.
Oliver, would you like to come back and answer that? So I'm going to ask the question on this behalf. So even where national debates haven't yet led to some kind of consensus, or where member states don't want to be pushed down that road, would even then be that approach legitimate?
Well, yeah. Well, I don't think. I don't think we need to wait for consensus as such, because I think that it's always evolving. So I don't see a judicial decision as putting having a final word. Of course, it will have an impact on the case, but it's I see that the debate as constantly evolving. So I don't see that as an obstacle impediment.
Thank you, Miriam. Can I use my position as chair? And although I'm neither a constitutional lawyer nor an EU political scientist, let me ask the elephant in the room question following on from Oliver's, which is, do you think that Britain leaving the European Union and therefore no longer in any way being shaped by CJEU law, do you think that will have any form of impact on the kind of cases and sort of discourses you've described going forward?
I think we should put the question to Colin, because I sort of was led by his article a lot on my observations about Brexit. I think obviously most of the benefits of the directive have been introduced into the Equality Act. So it is part of UK law, but repeal of the UK law would be more difficult. English courts could still follow, in theory, I guess, what the Court of Justice says in interpreting the directive, but they would no longer be bound to follow. I am worried because as Colin has shown, I think that the Court of Justice has had a beneficial impact on equality in the workplace. So it can't be good news as far as I'm concerned.
Given that you've so kindly put Colin on the spot now, Miriam, may I do the same and see whether Colin might be willing to comment here?
Yeah, just very briefly. I actually, it's Miriam's analysis is, I think, correct. It's actually quite an uncertain situation. On the one hand, UK anti-discrimination legislation is very strong and very well developed, arguably more so than in many EU states. Greater, deeper, longer tradition of it, much more case law, much more actively litigated. And the UK legal framework is very much up to date with the EU standards. What will happen in the future, as Miriam has said, is that Court of Justice judgments will be reference points, but won't be in any way binding. So in the future, you could see a scenario where the UK falls off in protection because of Court of Justice standards going beyond protection in the UK. Having said that, two very brief points to make. First of all, the ECHR, for now anyway, will continue to apply. And the current government has made some rather interesting noises about not wanting to leave the Council of Europe, leave the ECHR. So that will, for now anyway, will remain in play. And secondly, the political dynamic in the UK is very interesting. For example, one of the key target groups the Conservative Party needs to maintain its current electoral position over the next few decades are Hindu and Muslim middle-class minority groups. And that's very clear. Where I live in South London, we get targeted political advertising at our Muslim and Hindu middle-class minorities. And that's, it's very apparent. And there is no coincidence that the current UK government has ethnic minority politicians in very, very high-profile positions. It's the second most senior politician at the moment is a British Muslim, and that's, I think, going to be interesting. There are political dynamics that I think pull in a more tolerant, rights-respecting way. There are also, of course, the political dynamics around the Prevent programme that Miriam discussed, and xenophobia and nationalism as well. So I think how the UK develops is actually quite uncertain and quite difficult to know at this stage. But that's my own personal.
Thank you very much. Miriam, I wonder whether you want to sort of venture into the territory of prognosis as well, and see where you think the French case in in comparison might develop, and if there's any sort of shall we say European repercussion at the moment that you could see influencing the French law in this case.
I think I would be interested to have Stéphanie's and Philippe's views actually to give me a bit of relief, but happy to chip in afterwards.
Okay, so you like putting others on the spot. Well done, Miriam. You're quite right too. So Stéphanie, might I ask you first for your views on that?
Sure. I'll try to be brief. Colin was saying that UK anti-discrimination law had a very long tradition and was intensely litigated. This is a very different situation from what we have in France. French anti-discrimination law is not very actively litigated at all. It doesn't have a long tradition. And in fact, it has been oftentimes portrayed by politicians and legal actors alike as something that comes from foreign countries, that comes from the European Union, or that itself has been influenced by American society or American legal models, and therefore anti-discrimination law is very much seen as a vehicle for the absolute evil specter of communitarianism. This is important in the discussion that we're having because it also explains that many cases that have to do with laïcité in France and with the admissibility of a number of restrictions on religious freedom have not been litigated as matters of discrimination. They have been litigated as matters of constitutional principles or matter of constitutional interpretation, and therefore there's much more leeway for the sort of national identity, national culture, us versus them narrative than if we were in a more technical sort of burden of the proof, anti-discrimination form of litigation. So to answer your question shortly, the effect of European legal models, of anti-discrimination, be it from the EU or the European Convention, Article 14 case law, doesn't have a very big impact, or hasn't been having a very big impact on these issues in the ways in which they're framed in France so far.
Thank you very much, Stéphanie. Effectively, we're very close to the time we've set ourselves. I wonder, Philippe, if I might put you now on the spot and ask whether there's any concluding remarks from your end that you'd like me to bring in. You will have to unmute yourself, I'm afraid.
I beg your pardon, yes. Just a point very briefly, not as a legal expert on this fascinating question of Brexit and the future of anti-discrimination law and in a wider perspective, the question of religious freedom. I think one of the fascinating points, let's remember it, is that in the run-up to the vote on Brexit, the referendum in 2016, the decisive question was immigration, which led in turn to a rise in xenophobic, if not racist sentiments at large in the population. And it seems, according to polls now, and I'm really answering as a political scientist again, I'm sorry, that has gone down dramatically. So that could be, I think, a kind of a factual indication that hopefully rights and anti-discrimination rights might be preserved, because we know that governments and legislators tend, unfortunately, to react to some kind of what is perceived as the pop vox and popular mood. So that's the point I wanted to make.
Thank you, Philippe. And I feel I should apologize for bringing Brexit into the mix at all. We should aim one day to have a discussion on Europe that doesn't involve the B word. But can I just thank all of you for such a stimulating event and discussion. For a non-specialist, it was both extremely accessible and quite challenging as well to follow the intricacies. So I'm really, really grateful for you to have been able to follow your discussions. Before I finish, I think it's right to give the floor to Miriam once more, as we all congratulate her on the fantastic book that she's written, and we look forward to discussing many aspects of it with her going forward. Miriam, last words for today?
The last words have to be thank you. Thank you really to all for your stimulating questions. They open up ideas for future research. It has been a pleasure, and I'm really deeply grateful to you all for taking the time to reading the book so thoroughly and organizing BACL, Isolt, and Uta, and everyone who's attended, and all the speakers for the discussion today. Thank you.
Thank you. I think with that we have a wrap. I wish we could now all invite you for a coffee break and a little bit of an informal talk in the corridor. We'll have to postpone this and unceremoniously leave the meeting as Zoom tells us to. It's a pleasure seeing you, and until the next time, thank you.
Okay.
Thank you. Bye.
Thank you
Bye.
very much. Thank you.
Bye-bye. Bye.